The expression artificial intelligence is very often associated with big data. In fact, it is well known that in order to achieve the best results, AI systems are programmed to continuously process and elaborate enormous quantities of information and data concerning not only the environment around them, but also people, their habits, desires, movements, lifestyles, and so on. Therefore, among all fundamental rights touched by AI, the protection of individuals' personal data plays a primary role. That's the reason why GDPR introduces measures to deal with the critical issues that can arise when artificial intelligence systems process data. These same measures and the underlying logic and approach have also been taken up by the proposal for a regulation laying down harmonized rules on artificial intelligence, recently approved by the EU Commission. So, in this lesson, we will talk about the steps to make compliant with the law the use and processing of personal data carried out by AI. The first provision of the GDPR that comes to the fore is the obligation to take measures to ensure privacy by design and by default under Article 25. Concretely, this means that companies and organizations are encouraged to implement technical and organizational measures at the earliest stages of the design of the processing operations, in such a way that safeguards privacy and data protection principles right from the start. By default, they should ensure that the personal data is processed with the highest privacy protection. For example, only the data necessary should be processed, the storage period should be short, and the accessibility to data should be limited, so that by default personal data is made accessible to an indefinite number of persons. These principles are also in the heart of the recent proposal for AI regulation, which, with regard to data governance, requires measures to be taken from the design of high-risk AI systems to ensure proper, secure, and proportionate data management and processing. Another fundamental principle of the GDPR that has an almost physiological impact on the way AI systems are set up is the one related to the right not to be subject to an automated individual decision-making, significantly affecting the individual, which includes profiling and any systematic analysis of large amounts of data, revealing and predicting a person's habits, performance at work, economical reliability, behaviors, interests, and health. If we consider that AI systems operation and the decision-making process is entirely automated and usually does not involve human intervention, we realize the effects of this GDPR provision. In practice, compliance with it implies a limitation of AI's autonomous decision-making capacity, at least in the sense of always leaving a space for even minimal human supervision or intervention. Under GDPR, any processing of personal data must be granted by security measures, which must be tailor-made on the basis of a risk assessment to identify any foreseeable risk associated with data processing activities, considering the amount and the type of data involved, the means used for the processing, and their inherent dangers in terms of unauthorized access, disclosure, or loss of data. This means that no standard or minimal measure can be identified as universally applicable, and that they must be constantly updated according to the state of the art. This GDPR core principle, which is complementary to the principle of privacy by design mentioned above, has also been incorporated in the recent proposal for an AI regulation, which in fact provides that risk management systems shall be established, implemented, documented, and maintained in relation to high-risk AI systems. In addition to such ordinary assessment, GDPR provides for a specific data protection impact assessment, called DPIA, when processing activities using new technologies that are likely to result in a high risk to the rights and freedoms of individuals. In particular, DPIA is required in cases of automated processing activities involving systematic and extensive analysis of personal aspects and habits of individuals. The peculiarity of the DPIA is that if the outcome shows a high risk connected to the processing activity assessed, the supervisory authority must be notified, and the treatment must be suspended until the authority has given its opinion on the adequacy of the assessment and the measure to be taken to minimize the risk. As we can see, this is all the more important when we are talking about AI systems that very often dialogue with other systems, including third-party ones, exponentially increasing the risk of accidental disclosure and loss of data. Of course, to ensure a proper protection of personal data, all these measures adopted by the owner of the AI system which processes data must be adopted also by the whole supply chain. For this purpose, the data controller shall set out strict contractual provisions and also penalties that bind any provider involved in the usage of AI system and in the processing of data, and it shall ensure control over the means and security measures to be implemented by suppliers, also having the faculty to carry out audits and inspections on such suppliers. The right to data protection also involves two key aspects set out by the GDPR and also referred to in the proposal for AI regulations: transparency and control of data subjects over their own data. It means that individuals must be put in a position to know in a clear and comprehensible manner exactly who, how, and for what purposes their personal data shall be processed. Moreover, in specific cases, including profiling, processing is not lawful if it is carried out without the prior consent of the data subject, who must be guaranteed the possibility of withdrawing it at any time. The transparency principle implies also the right to access, rectify, and request deletion of data subjects' own data processed by others. The last aspect to guarantee as much as possible the right and freedoms of data subjects is the proper management of data breach. Under GDPR, if personal data get lost or distracted, altered or stolen due to a breach of the controller's security systems or an accident, an internal investigation should be immediately launched, involving all the suppliers that process the data, and any measure shall be taken to limit or eliminate as much as possible related damage. In fact, any data breach must be notified to the supervisory authority within 72 hours after having become aware of it, unless it has been assessed that the data breach is unlikely to result in a risk to the rights and freedoms of individuals. Should such risk be assessed as high, the data controller must communicate the data breach also to the data subject.